Hello and welcome to Unpublished Opinions, an Institute for Justice roundtable podcast, the podcast where IJ attorneys get together and give their unvarnished and unpublished opinions about the law. I'm your host, John Wrench, the Assistant Director of the Center for Judicial Engagement at the Institute for Justice. We are recording this on March 20th, 2026, and I am joined today by my IJ colleagues Diana Simpson and Patrick Jaicomo. Diana and Patrick, welcome on the podcast.
Thank you for having us.
Who's still varnishing things?
I don't know. I have used varnish before recently, in the last year for the first time. It was kind of
DIY project,
and I respect people's expertise in it a little bit more.
I think there's a connection to the "because I got high" theme here.
Because we haven't even gotten to that, but you're totally going to understand where Patrick is going in a little bit. before
not stereotypical libertarian yet.
I'm using varnish.
Before we get to that, we're going to start with some late-breaking Supreme Court news. This morning, the court handed down a unanimous decision in Olivier versus City of Brandon. That was the case about a street preacher who had been arrested for violating an ordinance that prohibits protests or demonstrations outside of a designated protest area. And so he's arrested. He faces a fine that's a little bit more than $300. He gets a year of probation, and he's threatened with 10 days of imprisonment if he violates the ordinance during the probationary period. He doesn't appeal. He pays the fine. But because he wants to continue preaching in the area, he files a lawsuit against the city, alleging that the ordinance violates the First Amendment. The city says that he can't file that lawsuit because of his kind of past experiences with the city where he had violated it and paid the fine. And so the issue in the case was whether this other case called Heck versus Humphrey barred Olivier from filing his constitutional challenge, and this morning the court said that it does not. Patrick, can you fill people in about the Heck bar and why it matters and your thoughts about the court's decision that it doesn't prevent Olivier from filing his lawsuit?
Yeah, you guys are going to love this. This is such an exciting topic. So actually, the Heck bar is one of the areas where our Project on Immunity and Accountability is working to tear down the obstacles between rights and remedies, because that's exactly what Heck is. And so the easiest way to explain Heck is to say that in this case, Heck versus Humphrey, you had someone who was in prison and was bringing a Section 1983 claim for money damages related to the reason he was in prison. And so the Supreme Court in Heck comes up with this sort of very confusingly based theory that you're not allowed to bring a Section 1983 claim for civil rights violations if that claim would invalidate an otherwise valid criminal sentence or conviction. And so to give you an example, it would be like you get arrested for something and you plead guilty and you go to jail, but then you bring a Section 1983 claim saying there was no probable cause for my arrest and you need to pay me $10,000. And the Supreme Court through Heck has said, no, we're going to bar those claims. There's a bunch of confusing reasons why, having to do with the language of Section 1983 and the language of the federal habeas statute and how these things interact and how some other concepts come into play. But the idea is basically that the Supreme Court didn't want claims for damages to be a way to collaterally attack criminal convictions and sentences. And so at least it makes sense in a theoretical way. It might make less sense if you dig into the legal bases for it. But its application in this case with the street preacher, Olivier, is really kind of bonkers coming out of the Fifth Circuit, because what they're saying is this guy got arrested for street preaching, and he decided, for a variety of reasons people make this decision, to just face the guilt, pay the fine, instead of going through a criminal process and having to get lawyers or whatever. There might be a bunch of reasons why you wouldn't want to do that, but that's done in the past. And so when he brings this injunctive lawsuit, he's trying to get this ordinance struck down. And basically the Fifth Circuit's ruling is, if you've ever been arrested for this thing in the past, you can't challenge it on an ongoing basis in the future.
Right. Even if you want the only relief you're asking for is so that in the future it cannot be enforced against you.
Correct. You're not trying to undo the way it has already been enforced against you. You're trying to say, okay, that happened and I thought that was bad and I don't want it to happen again. And so I'm going to bring a lawsuit to invalidate it. And that was a case that the court had decided previous to Heck. And it's one of the cases that Justice Kagan cites in the unanimous opinion. And basically the thrust of the opinion is the Supreme Court saying, well, in Heck, we use this very broad language, but maybe we didn't quite mean it as broadly as the language reads. And, tut to you for actually applying the words that we wrote in our opinion, lower courts and government defendants. But, as someone who litigates these issues all the time, I would like to tell the Supreme Court that sort of analysis is happening in every one of these cases. When you write a sentence that says, here's a new immunity, here's a new bar, here's a new privilege, the government will push it absolutely to its limits and pass those limits, and it will take 15, 20, 30 years before you can get the case back up to the Supreme Court to correct that. And so one of my frustrations with the Olivier decision, which is completely right, and huge shout out to Allison Ho, who argued the case. Congratulations. But at the same time that case went up, the Institute for Justice has a case called Wilson versus Midland, which involves a prosecutor who is acting as a law clerk in his own cases, who was involved in the conviction of our client, Irma Wilson. But Irma had served her entire sentence before anyone found out that this prosecutor, Ralph Petty, had been doing this sort of night work in his own cases, working for the judges that were then issuing orders against defendants. And so there, our argument is, well, Heck can't apply because there was no opportunity for her to have used habeas to get out of her sentence, because the entirety of her sentence was served by the time she discovered that this constitutional violation, this due process violation had taken place. And the issue essentially is the same one that was the question presented number one in Olivier, which the Supreme Court explicitly says, we don't have to address that because in Olivier, we're going to deal with injunctive relief and say that the Heck bar doesn't apply to that. And so not only does it leave open this giant gap, but then it also uses kind of similarly imprecise dicta in talking about, well, what does Heck do and what doesn't Heck do? And I think the problem that the court had recognized earlier in the opinion was we wrote this very expansive statement and the government has been using that as a cudgel for years. And now there's more expansive statements that are at least a potential for the government to use that way. And so right now that the Midland case has been held by the Supreme Court now for like a year, and we'll see what they do with it. It's going to go on a conference soon, and maybe they'll still grant to address this issue that they explicitly didn't address in Olivier. Maybe they'll GVR the case and send it back to the Fifth Circuit for it to consider in light of Olivier, even though Olivier didn't address the issue at hand. But I would love to see the Supreme Court finish what it started here by taking the Midland case up, because if it doesn't, the fight will just drag out for another period of years, and who knows if it'll be rightly decided.
Yeah, it's tough to see like you were talking about with Heck, there's that line, and I think it's something about, it's not just, it was being applied in a way where it's not just that it would undo the conviction, but like call it into question or call it into doubt, impugn it, something like that. And once you have a standard like that, how many things could you imagine using that language that could meet it? And the government is going to imagine lots of things.
Right. And so for that reason, actually, I think Olivier is a very helpful case for people in our line of work who are trying to brush back the government, which is often able to use these expansive statements by courts to reach well beyond the context of in which the statement was made. And so here, the language and the example that Justice Kagan gives is, in Heck, we said that you shouldn't be allowed to bring a 1983 suit if it would call into question the validity of a conviction or sentence. And she points out that technically the way the sentence is written, it's not even saying the same person can't challenge in damages what he failed to challenge in his criminal case. So theoretically, if you took that language in a vacuum and just read it, that would mean that, some completely unrelated person who gets arrested under the street preaching statute would then be barred from bringing a claim, because the street preacher's conviction would then be called into question by the fact that the statute was later invalidated. And that would mean essentially, if you can have anyone arrested and convicted of a crime, the statute under which they've been arrested and convicted can never be invalidated for violating the Constitution, which is, of course, kooky and not what Heck meant. And so for that reason, it'll be helpful to be able to point to Olivier as hey, look, the Supreme Court has again said you need to look at its statements in context and appreciate that what it's doing is not quite as precise as writing a statute or certainly writing a constitutional amendment. But at the same time, I think some of the examples that the court sort of throws around in Olivier are going to create the exact same problem that it just alleviated by deciding this case.
It's this like focus on finality that courts have that I understand that you don't necessarily want to litigate the same claim over and over and over again and with the same evidence, with the same people. Evidence gets stale. I understand that at a certain point you want to say, okay, this dispute is over, but not at the expense of being able to raise potentially meritorious merits claims about what happened, especially when evidence didn't exist or wasn't known at the time. And so what is a person supposed to do? They're just forever barred because somebody was out moonlighting in this deeply unconstitutional way and she had no way of knowing, and she's the one who has to go without a remedy for that. That can't make sense. That can't be the way that it is.
Yeah, I mean, my anecdotal evidence is that the courts play pretty fast and loose with the concept of finality and when it's kind of inviolate and when it isn't. But there's no question that if you just speak to regular people and you explain to them like, hey, the justification here is that you can't bring this cause of action because this other cause of action is theoretically available, even though it was never available to you, is something that most people are not going to accept. If they say like, well, you should bring a habeas case, and then you say, okay, I would. And they say, well, you're not allowed to bring a habeas case because by the time you found out about this, you were out of custody and therefore habeas is never available to you. And then a regular person would say, well, wait a minute, that doesn't sound fair. And the regular person would be right. And I think that the courts shouldn't be so easily dismissing the sort of impulse that most people would have when they hear about these sort of technical rules, which of course is the same impulse you get when you tell someone about prosecutorial immunity, which was, another issue in the Midland case, or qualified immunity, or a lack of a cause of action under Bivens or whatever. There are tons and tons of examples like this. And that's setting aside like all of the get out of jail free cards that are provided to the government when you try to bring injunctive relief, things like standing, ripeness, mootness, where you don't have those if you're bringing a damages claim, but you have just a different set of enemies to battle in every one of these cases. And in a disappointingly few number of cases are you actually battling about what does the Constitution mean, what rights do I have, and how can I enforce them?
It's like the best defense shield government could possibly imagine is having all of these non-merits defenses that are just procedural bars. And maybe some of them are valid if you want to give the benefit of the doubt to the government, which I'm not in the business of, but okay. Maybe some of them are valid, but they get them everywhere and they just are made up out of thin air. And it is a deeply frustrating experience as a litigator standing up for people's rights to get to the courthouse and say, okay, I've got someone who checks all of the boxes. And it's like, well, no, there's a new one and you didn't check that one. And you can't right a wrong that was done. And everyone would agree if you got to the merits was wrong.
Yeah, and I think it's particularly galling because like setting aside whether or not you're a lawyer or a civil rights litigator, just if you're an originalist or a textualist, almost all of these doctrines are made up on policy grounds by courts. And so this is another one of these sort of examples where the court wants to have it both ways, where it'll say, in the Erie decision, we said we don't do common law stuff. So we don't do policy weighing. We don't create things out of whole cloth. But then when it comes to immunities and those sorts of defenses and lack of cause of action stuff, you see the court's decisions almost always list off, paragraphs of why, for policy reasons, it's important that we shouldn't allow this person to be sued under these circumstances. And, you just want to do this. The sauce is good for the goose and the gander and say, we're either doing policy, in which case you can do it in favor and against the government, or we're not. I think even if you're not a textualist or an originalist, you should be able to agree with that point, which is that the rules should work equally in both directions.
Right. And it's, many of those doctrines, like you were pointing out, they've become so counterintuitive in like a very basic moral sense that even though that's not a legal argument, it is the very least a red flag that it's not a set of rules that you could ever get a majority support for from most people in the United States.
Right. And
it would be shocking to people that they are actually essentially procedurally barred from a bunch of different things that they think, of course, they have a right to.
Yeah, and I think it's interesting because the Supreme Court kind of talks about this in Olivier, which is to say, if Heck hadn't been decided, there's no way the Fifth Circuit Court would have made this up or thought it made any sense. Like, it doesn't make sense. Everyone kind of agrees it doesn't make sense. And instead you're just, doing your best to apply the rules that the Supreme Court hands down. And then the district courts are doing the same thing with 2 levels of those rules. And of course, we have an adversarial system. And so the government comes into court and says, well, we should push it even further than that. And, every time it wins, it gets a little sillier. And so we're kind of on the opposite side of all the silliness and trying to restore the sense of outrage that normal people would have if in the first instance the Heck bar was created in Irma's case. And so instead of saying, well, it's fine that we're going to apply it to her, people should step back and say, like, does this make sense in this context? And if it doesn't, what is this rule doing? And should we reevaluate this rule entirely?
Mm-hmm. Yeah, it'll be interesting to see where the court goes with it. And like you said, if there's what is left to do after the opinion, because it always takes a little bit of time and more litigation to shake out. So I'm sure we will be involved with a lot of those developments. Speaking of people reacting to some procedural attempts to punish people for exercising their rights, this may not be what people expected to hear, but we're going to talk about Afroman.
Got the varnish.
Yeah, there we go. So now we got all the way back to varnish. For those of you who are not hip, Afroman is a rapper. He was pretty popular in the early 2000s. There's a couple hits.
I'd say a little before
There's
then.
a couple hits. I mean, 2000 and 2001 were one of these hits is called Because I Got High. And the other one is called Crazy Rap, but is often referred to as Colt 45 because it's one of the more known lyrics of the songs. I think they were 2000 and 2001.
You're probably right.
But he was around, he was around late 90s, early 2000s. But he had some hits. And the songs are vulgar and funny and silly. And he's been in the news for something that is actually kind of related to rapping, but in a kind of unusual context. So he's been
isn't funny.
No, that is.
It
not
didn't start
funny.
out funny.
No. It ended funny.
It ended
very funny.
We're talking about that.
Yeah, this is definitely a turn to very easy good news. So he's been in the news because he won a defamation lawsuit. He was sued for defamation and won the case. And he was sued by 7 Adams County, Ohio sheriff's deputies. And it was all about a raid that happened in 2022. It was captured by cameras that Afroman had in his house. So you can see a lot of all the video essentially from the raid.
Well,
not all of it.
Until
the video line.
Until suspiciously the video is cut. So that will play into kind of some of the response that happens. And they're there purportedly to look for narcotics and kidnapping victims. But the raid term doesn't turn up anything. And in the process, I think $400 went missing. It was something like that. They took more than that, but I think they gave some of it back. But there was like a difference of $400. So following the raid, Afroman is angry about the raid. He's upset that they were there. They didn't find anything. He's upset that the money has gone missing. And so to kind of have some fun with it and also to react against them. And I think that he described it later in the trial as to turn a bad time into a good time. He made several music videos, and the music videos are kind of individually mocking officers. He's kind of mocking the police force in general. He calls them crooked cops.
Well, you're leaving out the part. He made the music videos using the footage from the raid that his cameras had captured before the police cut
of them destroying his front door,
the gate,
of them tearing the gate open. And I think he said that he originally did this to get money, like
Yes.
to crowdfund money to fix his front door from this raid.
And the other thing to keep in mind is, you started out describing this as a raid for narcotics and kidnapping victims.
Yeah.
That makes it sound way more serious and plausible than what it was. Like,
right. It's
at
more
the
Reno
time,
911.
It was very Reno 911. It was very Keystone Cop seeming. If you looked at the original warrant documents, there were like all sorts of typos and missing information, and like the theory of how he would have kidnapping victims in his basement when he didn't have a basement. It was all just like, anybody with a sense of reasonableness would be like, hey, are you sure, guys? Like, do we really want to go do this?
Right.
And that apparently didn't occur to any of these officers. And that brings us to the music videos.
Right. It kind of adds to the absurdity of it on his end, is looking at all of this. I mean, they had guns in his house. He has kids. Like, there's all of this stuff that he's pissed about it. So he starts making these music videos, and like Patrick said, they're spliced with the footage from the raid, and also like
inspired,
and they're extremely good.
Oh,
I mean,
can we just talk about the lemon pound cake? One of the officers he's going through the kitchen, and he's a portly man. I don't know if that doesn't seem unfair. Anyway, so he's walking past this lemon pound cake and
you might get sued
it.
for defamation,
in my opinion. and so,
is that a factual assertion? He's a portly man.
Sure is not. So he's walking past this cake and he does a double take and looks back, and it's like under like this nice glass cover. Yeah. It looks like a lovely cake, and
Mama's pound cake.
He just does this double take, and that clip shows up over and over again.
Well, that's what I said. When I said inspired, what I meant was the song is called Lemon Pound Cake.
Oh, it's so good.
The conceit is that Afroman is singing about offering this policeman a slice of the lemon pound cake.
Yeah, he's basically like, he takes that split second of this guy stopping in the middle of the raid to look at the pound cake to refer to him in the song as, I think it's in the song, Officer Pound Cake. The officer will eventually say at a trial, let me get to the trial really quick, because this kind of puts it in this great perspective, because you might think like, well, I'm sorry, like, how did we get to a trial? It's because he makes these music videos that upsets these officers so much that 7 of them sue him for defamation. And the basis is they have been, their reputations have been damaged, and their kids have come home from school and people are mocking. I'm not laughing at people.
You're laughing at the children?
I'm not laughing at people mocking their children.
I'd be laughing at the intentional infliction of emotional distress claim,
sure,
or the invasion of privacy claim, or the defamation claim. All of them are bananas.
And keep in mind, like, let's link this back. They sued him for defamation because he was mad and spoke out after they raided his house on very flimsy pretense.
Right. He made music videos that make fun of the officers who were involved, and they sue him for defamation. Now, you might think, well, this sounds like you're kind of risking Streisand effect issues, right? You're like, maybe a little bit. And
I don't think I would have listened to Lemon Pound Cake 6 times this morning if not for this trial.
Right. And, I might ask people, when was the last time you thought of Afroman? Because before a few days ago, many people, who didn't even know that there had been this lawsuit in the first place, until a few days ago, when the trial the fact that it got to a trial is kind of interesting. But
for those of you who haven't seen any of this, you should look it up.
Spend the weekend.
Afroman, first of all, he wrote another song about the trial in which he's wearing the garb that he wore to the trial, which was a suit in the form of the American flag and glasses that have the American flag over the eyes.
Yes, it is an incredible...
I love this country.
It is absolutely. It is an incredible theater, the entire trial. I would spend your weekend, at least some of the time, watching clips from the trial, because it's interesting and it is very, very funny. So it is during this trial, a lot of people have heard these songs for the first time because as part of the defamation trial, it's entered into evidence in front of a jury who is watching these videos. In rural Ohio, which means we're all watching these videos. So you just have this very strange, like, if your goal is for this stuff to disappear. Their goal was, I think they sued him for a little bit under $4 million in damages. So I get that the goal is to recover on a defamation claim. But what you just did is you kind of exposed the world to Afroman harassing you, and then people, I would say by and large, people thinking that it's hysterical.
Yeah,
so
you lampooned yourself.
Right.
Yeah.
So to Lemon Pound Cake, all of this stuff is shown, songs including Lemon Pound Cake are shown during the trial. And the officer who is the subject of the lemon pound cake video, there's this moment where he's on the stand, and the the lawyer says, do they call you Officer Pound Cake? And he says, yes, I don't know why, but yes, I've been many times. And I think he asks him, or the officer volunteers, that he's received like 100 lemon pound cakes in the mail.
Unjust enrichment case. Needs to be disgorged.
So you have all.
But no one called him lemon pound cake before the incident,
right? So you have this. So I'd like your reactions on all of this. The music.
I think the causation is clear.
The music videos, the trial. I mean, what do you think about it?
God bless Afroman, because I just. What happened to him was genuinely terrible, right? Like he's at his house with his family, which is like the most protected place you can think of. And these cops bust down the door, bust down the gate, break in, and they're taking video until they're not anymore. And so they turn off the cameras, and they abuse his rights the way that they abuse people's rights all over the country. And instead of just taking it, he used his gifts, his expertise to respond. And he did it in this like really fantastic way. And the videos are just, they're fantastic. You've got the beautiful baritone voice, and it's just, they sound great, silky. But they're very silky. But it's fun and it's funny, but like it wasn't funny at all. Like what happened to him was truly terrible. And I'm so grateful that that his response was, okay, let's shine a light on this. Mm-hmm. And then their insane response to file this lawsuit that has no basis in the law. I do not understand. I read the opinion on the motion to dismiss, denying it, saying that this has to go to trial. And I still don't understand how this is legally actionable. But I suppose that's neither here nor there. And so he goes to trial. He pays an attorney. He shows up at trial. They do all the depositions, all of the like really intense litigation work that goes into this to clear his name. And he releases a video on the eve of trial, which terrifies me as a litigator. What is my client going to do when they get up on the stand? And here he's like creating extra material that has already upset them. And
I don't think they're going to bring another lawsuit after this one.
Probably not. Probably not. But it's just... the whole story, like it's great. It's funny. I love it. I've watched these videos a lot and I'm really enjoying them. And I really appreciate that he stood up and fought back when this happens to so many people, and he could have been like a lot of people and say, okay, well, this was unfortunate. Let's just move on and never talk about it. And he stood up to the bully and he punched them back. And I'm very happy that he did that.
Yeah, I mean, I think, we're talking about something that is very funny in the form of the parody that Afroman produced after this, but the raid itself is something that's not funny at all. And as someone who's represented a lot of folks that have been victims of wrong house raids or raids for any other reason that was otherwise unjustified, like these are extremely traumatic events for people. And if it hasn't happened to you, and you haven't even interacted with someone that it has happened to, I guarantee you're not taking it as seriously as you should be, because this really is something that shakes people in their most sincere foundations of safety and security in their house, which is why the Fourth Amendment exists, because the founders appreciated this fact too. And so for that to happen, and then for him to respond in a from a free speech perspective and from an accountability perspective in a productive way, by, making this into a bigger story about a bigger problem. That in and of itself, like Diana said, was something laudable, I think. Whether you agree with the vulgarity of it or not is a separate issue. But then for the reaction to be that the police who raided his house under extremely flimsy circumstances sue that man is crazy. And so it's one of those situations that this is kind of beyond. We should start calling it the Afroman effect now. Like it's so much worse than the Streisand effect, because the Streisand effect is like, oh, now everyone looked at the house that you didn't want them to look at. This is, he made fun of me, and now I have to sit on a stand in front of a jury and the world with videos where I get asked about the things, the funny names that he called me, and question about how that made me feel, or the truth or falsity of whether Afroman had sex with my wife or whatever. And like, that is something you did to yourself.
Right.
And
They brought the defamation.
right. And I said to somebody who was talking about this, it was like, Diana, they were saying to me, I can't believe this got past the motion to dismiss. And I said, yeah, I bet you every one of those cops as they were sitting on the stand was wishing that it hadn't.
Oh,
like,
yeah.
At that point, we're probably on the roller coaster and it was clicking upward. But by the time they were going down under that first loop, they had to be like, I'm going to throw up and I wish I hadn't done this.
I said, oh, yeah, immediately. But I'm not sure that's true. One of them was sitting on the stand in this like the smarmiest way possible. And you could tell he was just like, oh, well, I didn't do anything wrong. And it's like he clearly did. And so how many other people's rights has he violated and, used the power of the office to try to get them to shut up?
It is like this weirdly perfect First Amendment America.
Yeah.
It's so strange how it has turned out that way. Like he definitely leaned into that, of course, with like you're wearing the flag suit with the flag sunglasses, but like all of his rhetoric, which I would say like it is like the way that he told his story during the trial, his reaction after the trial, it is so funny to have this like late 90s, early 2000s rapper who has these kind of funny songs that are hits to then re-enter American consciousness through being like he's like an Uncle Sam figure in that's how he's dressed, like in the trial. And like,
do you think he and his lawyer had like a debate about which of his suits to wear, and it was not one of the weed suits?
I'll tell you, it wasn't a debate. Yes, that suit was selected by Afroman. I can guarantee.
I think so. Yeah, and for the weed suit thing, like a lot of his clothing has marijuana leaves on his clothing, shirts, suits, etc. So it is interesting that he didn't, and that's kind of like when he performs, often he's wearing one of those things. So the decision to instead dress like Uncle Sam with an afro, and for his, and like as both Patrick and Diana have said, like it's not, what happened is not funny, and he tells that very well in the trial. Like when he's asked about it, it expresses how upsetting it is for them to raid his house with guns and scare him and his family, and how violated he felt. And his response to that, it was to do something, that he knew how to do. And it is just so interesting that I'm sure they're out there. I have not really seen any critical reactions to it. I'm sure they exist somewhere, but it's been a
bunch of killjoys somewhere.
Sure, but it's been in a
judges saying we're better than this.
Oh, we'll get to that. There's
foreshadowing, John.
There's been just like the veneer.
Someone's swinging around in the background.
Speaking of provocateurs, it's just interesting that it seems to have galvanized quite a bit. He's almost like an Uncle Sam Robin Hood character right now in the media.
I think if you want to understand the general sense of everything without having to watch any of the trial or watch any of the old music videos, which you should, I recommend you do those things, is in the immediate aftermath of the verdict, you've got this selfie recorded video of Afroman in the suit with the flag and a bunch of people, and he's just shouting about like God bless America. And as a civil rights litigator, as a lawyer, as a lover of America, as a true American in my heart, like it's one of those things that just hits you in the most visceral way of like, wow, this is awesome. Yeah. You can just tell. I don't need to know why anything leading up to this to know that this moment is great. Yeah,
it makes you want to like dump tea in a harbor. Mm-hmm. That's how that selfie video made me feel that way. Yeah. Yeah, it's incredible. So it's been teased a little bit. So now we're gonna get to it.
Teased.
Let's see how many puns and innuendos we can fit in here. So
without going into the explicit tag.
Yeah. So Afroman was not the only person provoking strong reactions. Last week, the Ninth Circuit voted to deny a petition for rehearing en banc in Olympus Spa versus Armstrong. You may have seen, it's been covered everywhere. So this is not like a late breaking thing, but I think that we can maybe talk about it from some directions that haven't been covered. So this is the case where the legal issue is whether a Korean spa violated Washington's anti-discrimination law by excluding a person who identifies as a woman but has not yet undergone sex reassignment surgery. So they still have male genitalia. And the Korean spa wanted to exclude that person from a female-only area of the spa where patrons who are as young as 13 are nude. And so if you haven't been to a Korean spa, some Korean spas or parts of others, there are portions of it that are nude. And in those nude sections, it is only men and only women. And that's kind of how the spa works. That is
I
just
have never been to one.
Really?
No,
I haven't.
I've been to a
learned
Korean
about
spa.
them from K-pop Demon Hunters.
Oh, interesting.
Well,
I've
I'm a
heard
never
that's-
nude, so this all sounds terrifying to me. But
There are dozens of them. It is like, so I have been to a Korean spa a couple of times, and it's kind of like they're not all like this, but for many of them, it's just like the men's side is just like the locker room section where people usually get clean and then put on a robe and then go out into a spa that is co-ed. And so it's feels more just like a locker room, I would say, where people are comfortable being nude. But some spas, like they kind of describe in the opinion, are more, and people don't have to be nude in all spas. So that's another thing. Like this spa is unique in that it is women only, and it sounds like you are basically nude in most parts of it.
My understanding is that there are certainly some category of spas where like nudity is not voluntary if you want to go into the spa, on the idea that the other people there will be uncomfortable because you're not naked and they'll make them feel weird about being naked.
Sure. Yeah. I assume that's true.
It's not a lifestyle that I am.
the jorts would be unwelcome.
I mean, where are jorts unwelcome? So the spa tells this person they can't come in, and
The Vatican.
And the issue is this anti-discrimination law. And so the case ends up being about the spa bringing these First Amendment challenges. They raise a free speech claim, a free exercise claim, and a freedom of association claim. The district court dismisses the spa's complaint. A panel of Ninth Circuit judges affirms. And then the petition for rehearing en banc was denied on March 12th. But not without some fireworks. So there are 6 separate opinions. There are 2, and we're not going to talk about all of them because I think that they all deal with legal issues separately. They all kind of, I would say, coalesce around a single opinion. They're all in some ways reacting to a single opinion, but there's 6 of them. And the one that has provoked a lot of responses is Judge VanDyke's dissental. And it's not really because of the merits of what he says in the dissental for why he thinks that the panel got it wrong. It's really because of the rhetoric in the dissental. So,
what do you mean?
So I'm going to tell you. So I'm sure that there will be a beep upcoming in the recording. So the most controversial language in the opinion is undoubtedly his statement in the very beginning that this case is about, quote, swinging dicks. But there are some other examples of I think things that people have found controversial outside of that, though they're not vulgar. They're more like decorum concerns or culture war concerns. So the other things that he says that have frustrated some people or that they've appreciated is that he describes the issue as being due to, quote, woke regulators and complicit judges, that they are the consequences of ideas ushered in by, quote, an elite cast of high-profile activists. He discusses the activist class. He describes it as privileging, quote, woke rights over natural rights, and then accuses the other judges of having a, quote, the fastidious sensibilities of a Victorian nun, and that the panel majority, quote, uses slick legal arguments and deflection to studiously avoid eye contact about the actual and horrific consequences of its erroneous opinion. Okay, so there have been a lot of reactions across the board. Some people think it's crass and insulting. There has been an interesting article, I believe it was in the National Review, that calls it postmodern. Some people have tied it to larger concerns about decorum and civility and judicial opinions. What do you think about all those reactions?
Just flop it out, Diana. Let's
Okay, so obviously this is language that you wouldn't expect. When you go into a courtroom, everyone has to stand up when the judges walk in. And how dare your cell phone buzz a little bit? And if you, God forbid, you wear a light gray suit instead of a dark gray suit or whatever. So like there's this sense of decorum that I think is perhaps gets a little involved with itself about courts generally. And for better or worse, that's just kind of how the judiciary is. And so to have someone come in their very first sentence say, this is a case about swinging dicks. It's like the glass drops on the kitchen floor and it shatters everywhere. And you're like, what did you just say? And I get the point, right? The point that he's making here is that if you can't have a conversation about what's actually going on, and that's male genitalia around 13-year-old girls, all of whom are nude, and whether that is something that a private business can constitutionally prohibit, like if you can't have that conversation with kind of clear eyes and clear language about what's going on, then maybe you're not actually having a clear conversation about what's going on and a clear debate about what the issues are. And I, in some ways, appreciate that because it's not... The people who are going to be suffering from this are the 13-year-old girls in that spa, and and not just the children, but adult women too. Women, I went to a women's college. I clearly believe in sex segregated spaces in certain places, and so to have this state law come out and say you can't have that, and to use case law from and to say that you can address that case law covers all of this, and so there is no redress for the spa is, I think that's a really important conversation to have. And he's drawn a lot of attention to this opinion in a way that I think a lot of people weren't necessarily going to look at, or they'd say, oh, it's just another day, another, case from the Ninth Circuit going this way or that way. And I think I would suggest this probably makes it less likely the Supreme Court grants review. I would say it probably makes it less likely that certain judges are welcome in other judges' chambers for afternoon lunch. I don't know. I don't know what their internal dynamics are. It's shocking, and now we're all having a conversation about it. And I think to some extent that's valuable itself.
I think as our discussion of the Afroman situation indicates, I'm a fan of panache and free speech and using outrage when necessary to get attention on certain issues. I think the question really that this case has raised, and I think when you were prefacing this, you were saying, some people called it crass. I think everyone agrees it's crass. I mean, I think
he even
the idea
recognizes,
his idea, and this,
if
you don't, if dear listeners, if you're not aware, this is not Judge VanDyke's first
provocative, interesting
opinion.
Yeah.
He also fairly recently issued an opinion that's just a video of him playing with a bunch of guns to demonstrate. I don't even remember what
he was demonstrating that the other judges had like a basic misunderstanding of how a gun functions, and so because
it was whether something was a firearm, and that was about like whether it was essential to the operation of the fire, whatever.
Right.
Either way, he did a video, and then that got a bunch of traction, and now he's got the swinging dicks case, and that gets everyone's attention. Swinging dicks, what? But I think the problem that Diana addressed right at the outset is Afroman is Afroman. Judge VanDyke is a circuit court judge in the federal court system at the second highest level that we have. And so if we think there's value to, and I do, the solemnity and seriousness with which we approach our court systems. So we go in and we stand up when they walk in, and we wear the suits, and we make sure that it's the right color of gray and whatever else. Then I think the judges should have a commensurate seriousness with the way that they approach these things. Because you're right, it got people's attention, but I don't think that the attention really was on the fact that this issue was otherwise going to pass them by. The attention was just on the meta question of like, wow, this is very flamboyant behavior, or this is a really crass ruling in a place that you don't expect to see crass writing or whatever. And honestly, I think I put this in the same category as the judges who try to write like a really funny opinion, or they try to like cram in a bunch of references to TV shows or movies because they think that'll make it interesting.
Humor doesn't work in legal writing.
Yeah, and I think the bottom line is, and the thing that's so frustrating and why the solemnity and pomp and circumstance are still so important, is that as funny as anything might be when you talk about it out of its context, every one of these cases involves at least two parties who have something very serious, at least ostensibly, something that they think is serious enough that they've decided to devote a ton of resources to having adjudicated. And so I think if you react to that with humor or some sort of shock factor or whatever, you're sort of disrespecting the seriousness of the case that these particular litigants brought to court. And I think that's something that we should never take off the table in the way we consider this stuff, because, especially folks like us who represent these people, we can imagine real people, but these judges see the real people too. And they should appreciate that every case involves real life, serious concerns of people. Obviously there's going to be frivolous cases or whatever, but that's not what the case where Judge VanDyke is writing these sorts of opinions. It's not the type of case that you get with like the silly humor or like, I'm going to write this whole case in like a Shakespearean lingo or whatever. It's just,
iambic pentameter for
John
20
rolled
pages.
his eyes, and that's right. I mean, that you should roll your eyes at this kind of stuff.
On the other hand, like, this isn't the first time someone has used kind of big dramatic facts, big dramatic language to talk about a case and to kind of recenter how you talk about a case. It's the first time I'm aware of this exact language being used.
Didn't have that on my bingo card.
Somebody might have done a Westlaw search already. I don't actually know.
I feel confident that you're not going to return much.
I'm loving the idea that there would be some other way in which those two words would end up side by side that has nothing to do with
probably like
phrase.
a graffiti case, right? Like bong hits for Jesus or something like that. I don't know.
Or maybe like a sentence that ends with the word swinging, and then the next sentence is a guy named Dick, and it's like possessive dicks.
Maybe something like that. But like, Justice Thomas, I think, is fairly well known in these death penalty appeals. When he writes, whether he's dissenting or whether he's writing kind of a main opinion or whatever, he almost always focuses on the crime that happened. And he comes out of the gate talking about sometimes with very colorful language, what exactly happened and who the victim was and what terrible thing came to them. And in doing so, he almost always says that their conviction should be upheld or their sentence should be upheld.
Yeah, that usually
Has
isn't.
he ever not? I'm not sure. Actually.
I don't think. Yeah, those are very rarely followed by.
I never want to say never.
Yeah, nevertheless.
But he tends to write in that way, and it's approaching it, I think, in the same way. It's saying, this is what we're actually talking about. And if you want to have a conversation about the law, then we should have that conversation in the context of the actual facts at issue. And so his are, I think, very flamboyant, just not in this exact kind of choice of word way. But I think they're also effective.
So my thought is I think they're separate categories, because obviously, what you're describing is something that other judges do too, where you say like, okay, if we're going to talk about whether this person should be executed or not, I'm going to describe in great detail the terrible thing they did. And there's other cases that aren't, involving death penalty or whatever, where you could see the same thing happen. And I think that's totally fair. I mean, you could see this same opinion have been written without the phrase swinging dicks. And it wouldn't have gotten as much attention, I don't think.
There are other statements respecting denial that are not that opinion,
right,
and do just focus on the merit.
And they've all been overlooked because of the swinging dicks thing. But I think what I would say a more appropriate analogy that we would, I hope, all think is inappropriate is if instead of talking about, the grisly aspects of a murder and upholding a sentence of death, if Justice Thomas wrote instead and used a bunch of puns like, in this electrifying case, we are asked to determine whether the electric chair can be used to kill. You know what I mean?
That would be terrible.
Exactly. It's just gross behavior because it's not taking seriously the solemn task that we expect of judges. Judges wear black robes for a reason. They are supposed to be sort of this avatar of, neutral and serious decision making. And so you can disagree with that. We could all transition to like a system in which the court walks in wearing Hawaiian shirts and says what's up and smokes cigarettes on the bench or whatever.
Sounds pretty cool.
Yeah, it could be kind of neat, actually.
Cigarettes are gross. What are you talking about?
I'm more thinking about
Cloves.
It's 2026.
Talking about cloves.
It's cool.
Clove cigarettes. Those
Yeah,
are
it's
cool.
cool.
It is
You
not
s-
cool,
You see
John.
Mad Men? It's
Maybe
so
they're
cool.
smoking doinks. I don't know.
I don't even.
Afroman is going to be a joke.
Exactly. You can imagine a world where the courts are populated by Afromen.
Yeah.
You know, and they're wearing big, colorful suits or whatever, but that's not the system that we have.
It's this future I want.
And if it was a system we had, I think it would change the way that we view, the administration of justice. And so I think it's both important for us to examine that. And again, to the very first point Diana made, to recognize that like courts expect the litigants and the attorneys who come before them to behave with a certain level of seriousness. And if they themselves are then unburdened by that seriousness, it starts to become a problem where the litigants and the counsel will say, well, if you can write an opinion like that, then just wait till you see what I turn in. And granted, that's happening now because there's a lot of silly people that are able to pass the bar and plenty more so when it comes to pro se plaintiffs. But that's my concern. I think he could have said the same stuff and he just didn't have to use the
I mean, maybe, but like respectfully, there is one of the dissentals that I'm thinking about. No one would have talked about it regardless of whether there was a dissental about swinging dicks. And so it's the statutory question is a dry statutory question, and now people are having a conversation about it.
I guess I wonder if we would be having the same conversation if instead of Judge VanDyke's dissental, we were talking about like a video of the oral argument where the counsel got up and said, "This is a case about swinging dicks." How would the court have accepted that in that moment?
They brought their toothbrush.
I don't think exactly. That person might be in a jail cell
for contempt. Yeah,
for saying that.
And
so like just the basic fairness of like, well, why would we put them in jail for contempt? It's because of these same solemnity concerns, the same concern of like being, it's like saluting the rank instead of the man type of thing.
Yeah, I mean, there's something I definitely am sympathetic to Diana's point about there's many ways in which the real issues can get concealed under language, like especially legalistic language. And I was thinking about Justice Thomas's death penalty opinions in this context as well, where it is. But I think where I come out on that is it's something like this. There's a reason that like George Carlin's bit about shell shock, where he's talking about how language like used to be very like direct, like what it is about because it is very straightforward, and then it becomes coded in something more. It's sterilized, and because it's sterilized, you're actually like farther away from the reality of what the thing is actually talking about, and that makes us more comfortable. And so, did you just think of a George?
Yeah, I'm ready for the George Carlin in my head.
So like I'm sympathetic to that, and I do think that there are really useful times where judges can, and maybe in a way that litigants don't have the benefit of, and that's okay, that judges can kind of peel it back and really get into the reality of what's going on. And I don't think that there's anything objectionable about that. I actually like that when it's used well. I think my main concern is when those things are most effective and when you're going to be provocative. I think that those are probably best used in situations where like it is kind of the only option you have. Like if you took a step back and there had been 20 years of people litigating cases like this on behalf of spas or similar businesses, and the Supreme Court would just not weigh in on them, and they were just kind of letting it happen, and there was always culture war issues going on, and you're a judge who disagrees with them and is like, I've written so many of these, just like we're going through the legal issues, blah, blah, blah. Like the court is not, I'm just screaming into the whirlwind, right? It's not happening. Then I could really imagine being like, you know what?
Right.
Why not? Like, why not kind of throw this out there to kind of try and break this? But I think that's an unusual decision to me here, because this is not the kind of case that the court is going to be like, oh, nah, I don't care. Right? Like it's almost exactly the kind of case that if you just have pretty standard opinions, like this is on the court's radar. Like issues like this are on the court's radar, and we know that for a fact because they've granted in other cases that have similar issues. So I don't think resorting to the the kind of like last ditch effort where like all you can really do is write the satire or the parody. I'm not sure why you do that, because we haven't really talked about the other, like the merits of the case. And yeah, I mean,
it's a poison pill for the case if anybody wants SCOTUS to take it. I suspect, because if they take it, now it's the Supreme Court has taken a case about swinging male genitalia, and then it's an issue about it's a case about that, and it's all of a sudden a culture war case, and it would have been a culture war case anyway given kind of the facts at issue, but even more so. And it's not going to be a question about free exercise or freedom of association. It's going to be a question about swinging genitalia. And you know, I suspect the court is not terribly interested in having that circus show up at 1 First Street.
Yeah, I'm not one to clutch pearls, but you know, I think, and you know, I've observed it with much less acuteness at different courts, you know, that I've practiced in, where you see like a court that has the sort of collegiality gets destroyed, and so like, sure, it might get a bunch of it. This is going to have to be bleeped. It might get a bunch of attention if your dissent says, like, my colleagues are a bunch of That's the first sentence, right? Wow, that's going to be in the newspaper. But I mean, the other thing is that then you start losing the ability for the courts to even sort of interact in a way that I think they need to be productive, because then it starts to become like this really unpleasant war of personalities, and like I really just dislike this person. And of course, like you can look at the Supreme Court and see famously you had people that like vehemently disagreed, like Ginsburg and Scalia, who were like very good friends outside of the court. And I think this sort of thing probably, you know, serves as at least a quite lasting reason why you'd be like, all right, well, I don't want to see that guy in the hallway for a minute.
And
like,
we have examples of those too on the, like in history,
Yeah.
where there are justices like Frankfurter, for example, like who was you know, people could not deal with the way that he interacted with people, and like that has consequences legally, like for constitutional
I'm
doctrine.
not going to join your concurrence.
Right.
I'm not going to vote with your majority because I just dislike you.
Right.
And so, you know, I think there's a bunch of reasons why, as you know, if you support one side of this case, if you're not, you know, particularly nuanced in your approach to the way the law works, like obviously I understand why you'd see this and think it was funny and think it was amusing and share it with your friends and whatever. I don't think fundamentally it's moving the ball forward for the issue in the way that Judge VanDyke might like.
Yeah, I mean, in some ways it's like if you're in favor of the outcome, it's kind of an expression of like the id of the issue, in the same way that I might expect like a legislator, like if you agreed with Judge VanDyke's approach, you would also probably like to see a legislator say some of these things to kind of like cut to the issue. And that seems, I mean, that would make sense to me if that's your kind of perspective on it. But I think some of the concerns about it are kind of like, well, what happens when that way of addressing these issues becomes, if it could ever become the norm, which I don't think it's leading that way, but it is a, you know, it's worth asking, like, is this even, putting aside, you know, the merits of it, like, is it just practically useful to achieve the things that you are trying to achieve with the opinion? And
well, I don't think we know.
I don't think, I guess we'll find out.
We'll find out in 90 days or so.
Yeah.
Yeah. You know, I just think the next time some litigant or attorney comes to the court and behaves this way, this will be a counter argument that they can make to explain why they should be allowed to do this too. Now they're going to lose. Don't do that.
Still bring your toothbrush.
That's right. You're not going to like how it works out for you,
but
because
shoot your
you're
shot.
not a circuit court judge.
Yeah.
But still, I think like that's the thing we're all dancing around.
Yeah. All right. Well, Diana and Patrick, thank you so much for being on the show. To our listeners, I hope you enjoyed our conversation. Be sure to tune into our next episode. And until then, that's just like your unpublished opinion, man.